Please proceed, counsel.
Good morning. May it please the Court, Madonna Georges Blanchard from the Wayne County Prosecutor's Office on behalf of the people of the state of Michigan. I would like to reserve 2 minutes for rebuttal.
So done.
This Court in People v. Toma, written by Chief Justice Markman, stated that no trial is error-free, and in our judgment, public respect for the judicial process is justifiably diminished when criminal convictions are set aside on the basis of mistakes that do not truly prejudice the defendant or damage the integrity of the criminal justice system. Here, the Court of Appeals unmistakably applied the law in an erroneous manner and equally unmistakably caused a material injustice to the victim's family who, because of the Court of Appeals' opinion, will have to relive the trial against a defendant who was properly convicted of first-degree premeditated murder unless this Court intervenes. Therefore, this Court should reverse the Court of Appeals' opinion and affirm the jury's verdict for the following 2 reasons. First, the Court of Appeals failed to properly apply the miscarriage of justice standard, failing to examine the entire cause and the actual prejudicial effect of the error on the trier of fact, on the fact finder. Instead, the Court of Appeals acted as a jury and reversed the jury's verdict by only examining in isolation the evidence presented by the people and the failure to give the requested instruction, making no mention of the contents of the one character witness's testimony or the other instructions given to the jury. My second reason is that there was no error in the first place because the jury instruction on evidence of defendant's good character should not be given. But because this case doesn't need to be, can be resolved by determining that there was no miscarriage of justice, this Court doesn't need to decide whether that instruction was necessary, so I'll focus on my first point. I would like to note that there is a case on point that I did not cite in any of my briefs. I've contacted opposing counsel and informed him, and I've also emailed him a copy of that, and that is People v. Hawthorne, 474 Mich. 174, 2006. In that case, the defendant was charged with first-degree murder and felony, first-degree murder. And defendant's sole defense was that his actions were done accidentally. He killed the victim on accident. That was his defense throughout the entire trial. The defendant asked the trial court for the accident instruction, and the trial court refused to give the instruction. Now, this Court found that the trial court's refusal to give the accident instruction was, in fact, error.
Counsel, I'm going to go read that case after the argument, and I look forward to reading it and learning what I can from it. It's not that helpful for us when we haven't had a chance. I appreciate that you gave it to opposing counsel, but since we haven't read it, it might not be the best use of your 15 minutes because it would be hard for me to evaluate how much the instruction in that case mattered given the other evidence. So let's just go back to what we have in this case. And I also appreciate that you have asked us repeatedly to take up the argument that this is an instruction that shouldn't be given. We have declined that invitation, and instead we just asked you to focus on whether it made a difference in the outcome here. So turning to that, I want to ask you about the actual the briefs have all focused on the judge's failure to tell the jury the one part of the instruction that the defendant considers the most helpful, that the jury could, if it believed the defendant's character evidence, find a reasonable doubt based on that evidence. And nobody disputes that the judge did not give that instruction. When I went to read the judge's instructions in this case, I was struck by how many instructions on both sides, frankly, the judge failed to give during the trial. I don't know what's going on there, but when the parties reminded her, this was one of them, and she then gave the instruction, she not only didn't give the part that the defendant thinks would have made a difference, she actually misinstructed the jury about the character evidence. She said not only that the defendant presented character evidence, but then she said the prosecution presented evidence to rebut the evidence of other character evidence, which wasn't true. So isn't that a separate problem with this instruction that nobody's really focused on? Admittedly, I didn't see anything about it in the defendant's brief, nor did I see anything about it in the Court of Appeals opinion. I found it myself when I read the instruction.
Right. Actually, the first Court of Appeals opinion addresses that, and I believe it's only in a footnote and states that they did kind of make a mistake, but it's not something that would rise to the level of error, so we're not addressing it here. I'd also like to note that I know that the record reflects that it was Judge Brennan, who's the trial court judge, but she wasn't actually the one who tried this case. It was actually Judge Lacey, who's never tried or never been a judge of a murder case. He was a juvenile judge before and was standing in for Judge Brennan, who wasn't there.
Oh,
so I think
that's interesting. I didn't know that. Okay.
Right. So
yeah.
and I think the parties both had complications in trying to conduct the murder trial the way that they're trying to in the proper form. You could tell in in the transcripts about requests from the jury to see the complaint or the first warrant wasn't evidence, and so it was a complicated trial procedurally. So I think that it wasn't addressed, that issue, because
When you say complicated, you mean the judge made a whole bunch of mistakes?
I think that both parties had to work to ensure that the procedures and the rules of law were
The
properly
answer
applied.
is yes.
I don't think so.
Should it concern us that this judge, I'm glad you pointed out, because I was wondering how Judge Brennan managed to do this, but it sounds like she wasn't around, and we had a stand-in judge who had no idea what he or she was doing, which now makes a lot of sense to me because the judge forgot to read a whole slew of instructions, right? All the fives, all the witness instructions, some other ones.
The witness instructions were read. I don't think it was a judge.
No, let's go back. They weren't read. And the parties, then the attorney said, here, judge, here's a whole laundry list of instructions, numbering 6, 7, 8.
The first time.
The prosecutor jumped in and said, hey, by the way, you forgot the inference instruction as well. And the judge said, no problem. I'll give those instructions, and then proceeded to bungle all of those instructions, including the one the prosecutor requested when they started to read about lying in wait. And the prosecutor jumped up and said, Judge, this case is not about lying in wait. Oh, no problem. We'll tell them to forget about that, and we'll go back to something else. I mean, so the jury is sitting there listening to these instructions, and I can just imagine the defendant thinking, I'm on trial for a life offense, and this is the kind of procedure that is followed?
Well, I'd like to note that the instructions were read to the jury, the witness instructions, and all the instructions.
Are you denying that they were? I mean, they were not read initially until the defense lawyer said, after the instructions were read and apparently the jury was dismissed, Judge, you forgot a dozen instructions.
Right. So the jury went back, and then they were called back into the courtroom, and then additional instructions were read without any problem. I mean, the jury didn't know that.
Not without any problem. This instruction, the judge actually turned on its head. She did not give the part that would help the defendant, and she misinstructed the jury about the character evidence.
Right. Okay.
But let's be specific, because I spent some time with this myself. When the issue of the character, let's forget about all the other bungling. We'll just focus on this bungling.
Since that's the one that's before the court.
Right. I just wanted to put it in context, because it helps me understand how this was so screwed up. So the instruction wasn't objected to. Everyone agreed upon that this was a correct instruction. The judge forgot to give it. The judge was reminded to give it. When the judge came back, the proper instruction was 5.8a, character evidence regarding conduct of the defendant. The judge gave some poorly modified version instead of 5.8, character evidence regarding credibility of the witness, the first paragraph. Then went on to give the second and third paragraphs of the instruction regarding conduct of the defendant, which weren't supported by the evidence, which actually favored the prosecutor, but weren't supported by the evidence in this case. So not only was not the correct instruction given, but incorrect instructions were given in its place that further disfavored the defendant. Would you agree with that?
No, I wouldn't agree with that. I would agree with the
Did
first part.
I misstate the facts?
No, the facts I agree with.
The transcript?
That is undisputable. We have the record that did in fact happen. Now, whether it further hurt the defendant, absolutely not, because it just talked about things that don't even apply to the case, the facts that were presented in the case. The other instruction given.
Use paragraph 2 only where the prosecutor has cross-examined the defendant's character witnesses concerning reported conduct inconsistent with the claimed good character. That didn't happen here, right?
Right. That didn't happen, so it's not relevant. They were given that
But the
instruction
judge
to evaluate.
Don't we maintain this understanding that the jury, in fact, follows the judge's instructions?
Right. So they're instructed to look at the prosecutor's cross-examination of the character witness, but there was no cross-examination of the character witness. So that instruction it means nothing to the case. So they're instructed to do that, but it didn't occur.
But it further focuses the jury on whether or not they should believe those witnesses, even though that cross-examination didn't take place. And then the third paragraph, whether the prosecutor has called adverse character witnesses. The judge said the prosecution has also called witnesses who testified defendant did not have a good character of the other acts, whatever that means. That didn't happen either, right?
Right.
So if you're a juror, you have no idea what the hell the judge is talking about at this point, right?
Well, if you're a juror, you're also listening to the other facts or the other instructions that the trial court gave. And the most important...
Like the lying in wait instruction and other ones that don't apply?
No, but they were also instructed that they had to listen to each of the witnesses' testimony, that they were the sole persons that were going to decide the facts of this case. And above all, they were told all the elements of the crimes that the defendant was charged with, and that they had to prove each of those elements beyond a reasonable doubt. And the finding, so we have to say, okay, there was a mistake. The instruction was not given. There was an incorrect instruction.
Part of it wasn't given, and then the parts that were incorrect and undermined the actual evidence.
Now, so there is a mistake, and we cannot reverse the trial court.
2 or 3 mistakes.
Right. So there are, no trial is error-free. Now, what we have
Some more than others.
Correct. But we have to decide, are those mistakes rise to the level of a miscarriage of justice? Did they change the outcome of the proceedings?
So do you agree that in this case that the evidence largely amounted to a competition between the Kuntz family's words against the defendants? Because it was 30 years old, I understand that probably, disadvantaged the prosecution. Also disadvantaged the defendant, right? 30 years is a problem on both sides.
But why was this case tried 30 years late?
Well, when the crime originally happened, there was a warrant out for his arrest. It was sent into the lien system somehow back in the 80s. Somewhere in between there, it was removed from the system.
He absconded.
Well, yeah, he left the state first.
Yeah, that's interesting. I expected you to say, in response to Justice McCormick's line of questioning, I was trying to be helpful.
Thank you.
Oh, the defendant fled the state.
Right.
But now I'm interested. It now sounds like maybe he didn't flee the state. So tell me about how the state screwed up. I thought this was going to be on the defendant. But
Well, this is, the reason why it's taken so long is because the defendant absconded. He was not in the city or the state of Michigan. He moved to, I believe it was Mississippi, and then he stayed there for several years. And we didn't know this until afterwards. The defendant told us where he left and why he left Michigan. But then subsequently, Highland Park, the case was a cold case and wasn't continuously followed up because the Highland Park Police Department shut down, and then
it was blown away.
Then it opened back up, and then there was more. They were going through their cold cases, and one of the
regardless
victims
of whether the defendant absconded or the police made mistakes and didn't enter properly on the lien, does that change the burden of proof in a criminal case?
Absolutely, and I want to take this back to what we have to focus on. So I'm not disputing that an instruction that was required.
You say absolutely it doesn't. Well, she said absolutely, but I didn't.
No, it doesn't change. The fact that he left or the fact that we're here 30 years later, that doesn't.
The prosecution still has the burden to prove each element of the crime beyond a
we still
reasonable
have to
doubt.
prove each element, which we did beyond a reasonable doubt. They were presented to the jury, and the jury found each element beyond a reasonable doubt.
Was the evidence particularly strong in this case, would you say?
Well, you know what? The evidence, and the Court of Appeals, this court, last time I was here, had focused on the evidence. Now, what we have to remember is that when we're looking at that evidence, that was the evidence that the jury convicted the defendant on. A trier of fact listened to all that evidence and found that based on that the defendant was guilty beyond a reasonable doubt. Now, to believe that the failure to give this character witness instruction changed the outcome of the proceedings, we have to believe that the jury heard all the evidence in the case. They heard defendant's one character witness who only testified to his peacefulness. Several years earlier, she did not live in the city of Highland Park when this crime occurred. She had left in 1980. This crime occurred in 1983. So she's just this one character witness who did not live in the area. She visited occasionally through that time because she was away at school.
We're familiar with the record, but you do agree with me that the question came down to, do we believe the defendant or do we believe the Kuntz family, right? There was no physical evidence. There was no other evidence from which we could determine. Okay, so when that's right, would you agree with me as a general matter, a character witness might matter a little bit more to a defendant's attempt to...
maybe a character witness matters, maybe it doesn't. depending on the situation.
When
But
it's,
here,
when it's we believe him or we believe them. We believe him or them.
right.
In that case, would character evidence matter a little more?
But it matters a little bit more to present that defense, perhaps by the defendant.
But not to have the jury properly instructed about what it might mean?
Well, so this is the thing. So to decide that failing to give the instruction, by failing to tell them what it means, would change the outcome of the proceedings, would have to define that
What did the character witness say?
The character witness said that when he was a peaceful person, and she based this on an experience she had in high school. She graduated in 1979. That when she got in she was going to get or got in an altercation with another person, the defendant told her, "Don't fight. Do something with your life. You don't need to fight somebody." And so she considered that he was just generally a nonviolent person. So what I want to just get this one point across is that to make the outcomes of the proceeding different, the jury would have to believe that defendant was a peaceful person. He was not capable of committing this crime. But they didn't know what to do with that information because they weren't told that alone would mean that would raise a reasonable doubt that he didn't commit the crime. So they're sitting there thinking, he was a peaceful person. He's not capable of killing Andrew Weathers. But I don't know what to do with that, so I'm going to find him guilty beyond a reasonable doubt of first-degree premeditated murder. They also read the instruction on second-degree premeditated murder, and that's what Hawthorne says. It says, finding that the defendant, he was ultimately convicted of second-degree murder, finding that he had the requisite intent of malice is wholly inconsistent with the finding that he accidentally killed the victim. So the fact that the jury found that he had the requisite intent of malice is inconsistent with the finding that he acted accidentally. And here, the jury found that the defendant had the requisite intent of first-degree premeditated murder. They weren't sitting there thinking, he is incapable of killing this person because he is so peaceful, but I don't know what to do with that because the judge didn't instruct me that alone could cause a reasonable doubt, because they turned around and also looked at all the elements of the crime, and they found him guilty beyond a reasonable doubt of each element.
Okay. Your time is up, counsel. Are there any further questions? Thank you very much. Mr. Rust.
Good morning, Your Honors. Daniel Rust appearing on behalf of Mr. Lyles. Justice McCormick and Justice Viviano, you summarized my position actually quite adequately. Mr. Lyles had presented witnesses to his reputation in the community around this time for being a peaceful person. That was the only evidence that he could present to the jury. The prosecutor presented circumstantial evidence against Mr. Lyles from a 30-year-old offense that he supposedly committed. On that basis, what did Mr. Lyles have against or for him? What did he have to present to the jury? Just his reputation at that time. Yet when properly requested, the court did not instruct the jury on how to treat this evidence. The judge, in this instance, basically, as I think one of the Court of Appeals opinions said, bollocksed the whole situation. This, coupled with all the other instructions that the court gave to the jury, just, I would submit, confused the jury to no end. They had no idea what to do with all this evidence. All they had to do was look at the evidence from the prosecutor's viewpoint and say, Mr. Lyles is guilty. We don't know what the jury did in the courtroom, in the jury box. We don't know what the jury did with the evidence that was submitted by Mr. Lyles. We don't know how much weight the jury gave that, if they gave any weight at all. But I would submit, when the jury was instructed with improper instructions, for example, the fact that they were instructed, the prosecutor presented rebuttal testimony, what did the jury do with that? I'm assuming, since jurors are expected to follow the instructions, that they just rejected it out of hand.
Well, what was so confusing about the evidence, Mr. Rust? Having sat there and listened to the character testimony, what would be confusing about it? What would the jury reflect upon and say, we just don't understand what the purpose of that evidence was?
They were not instructed properly by the judge.
We understand that. There was clearly error here. But we're trying to understand what the significance, the consequences of that error was. And I'm trying to understand what confusion would have been occasioned in the minds of the jurors such that this instruction that wasn't given was absolutely indispensable to their interpretation of what they've just heard.
Because if they were properly instructed, they would have been informed that Mr. Lyles presented evidence from his reputation in the community. Instead, they were told something about whether to judge the truthfulness of the witnesses.
So, counsel, you began your argument, I think, exactly as the Court of Appeals presented it, which is Mr. Lyles had one defense. His one defense, the only thing he could bring to the court was his reputation for peacefulness. And he wasn't fully allowed, although he was allowed to present the evidence, the jury wasn't fully allowed to consider that because of the instructional error. But the question before this court is not whether he was allowed to present the only defense he might have, however weak that defense might have been. The question we're supposed to ask is, if he had been allowed to present that defense fully, is there a reasonable, no, actually I think our standard is by a preponderance of the evidence, would we believe that the jury would not have reached its verdict of beyond a reasonable doubt? So the question is not, was he allowed to present his defense, as weak as it might have been? The question is, if he had been allowed to present his defense, would it, by a preponderance, overcome the jury's verdict? So
Yes.
that's a different question, right?
I agree, and the answer is yes. Because
But that's not the question the Court of Appeals answered. The Court of Appeals answered the question differently. Do you agree? You disagree, maybe.
I would disagree. You instructed, when you remanded the case back down to the Court of Appeals, you asked it, or not asked, ordered it to decide the case under the standard set forth in Lucity. The
Right.
Court of Appeals did that, and they nonetheless still found, given the totality of the case.
Well, they said Lucity. They said that. But then they also said the problem here is that the defendant wasn't fully allowed to present his defense. But that's not the question. If the defense was very weak, it doesn't really matter.
But we don't know how weak the jury determined that.
Well, but if that were the case, what you're trying to say now is, look, a jury is a black box. You can never undo it. You can never unscramble an egg. If that were true, then we couldn't do harmless error analysis at all. We couldn't do this inquiry. We would always have to find whenever there's an error, you automatically get a new trial. That's what the Court of Appeals said the first time around, and we said, no, actually, you have to do this harmless error thing.
And I agree. In some instances, if a jury is improperly instructed, it may be harmless error. But under the facts of this case, given the nature of the evidence presented.
So explain that. Explain why, if the jury, although it heard the character evidence, if the jury had gotten the proper instruction on the character evidence, it would have overcome the evidence from which a reasonable jury could have and did draw a conclusion that your client was guilty beyond a reasonable doubt.
Yes.
I'm asking why.
Oh,
What? Explain to me how this piece of evidence would have changed
Because the only
everything.
evidence that was presented to the jury was circumstantial evidence alone.
Right.
Nothing. And I'm sure you're familiar with the facts of the case. There was no physical evidence at all.
Got it.
30 years old. It was all the testimony of primarily one witness. Now,
But the fact pattern is pretty limiting. If you start with the proposition that the assailant broke into the basement of a home, unscrewed two fuses that disabled the electrical system, put the puppy that inhabited the basement in a freezer so it wouldn't bark, and then went upstairs and assaulted with a knife from a butcher block in the kitchen the victim. There's an interesting coincidence. The defendant happened to have lived in the house before, and also had used a knife from the butcher block to assault somebody, but stabbed I think, a bed. I mean, yes, that's a circumstantial case, but the nature of the crime is sort of identifies the number of people who could probably have committed it.
True, but in Mr. Lyles' defense, he said, I couldn't have done it because I'm a peaceful person. Here's my witnesses that said I'm a peaceful person.
Okay, I hear you.
But the jury wasn't told how to consider that evidence.
But if they had been told, why should we think that evidence, I'm a peaceful person and therefore I couldn't possibly have committed this murder, would overcome the evidence that the prosecution presented, which it was not the strongest case in the whole world, but you don't contest that it was sufficient for the jury to have found on the evidence presented that it was that there was a proper finding of beyond a reasonable doubt. So I just don't know how I'm a peaceful person overcomes the evidence Justice Young just talked about.
But that's a jury determination. You do not.
I understand that.
So you cannot say what weight the jury would have given this determination that he is a peaceful person.
Okay, so I understand that too.
Do you think it would have been helpful for the jury to learn that evidence of good character alone may sometimes create a reasonable doubt in your minds and lead you to find the defendant not guilty?
Yes.
So that's a reason why they might have reached a different conclusion if they knew that evidence by itself, if they believed it, was sufficient to overcome the relatively weak circumstantial case that the prosecution
might
presented.
have, as Justice Viviano just said it?
Yes, it may.
It might have. That's the standard. Your burden is to show that the jury might have?
It's in the jury instruction that one.
No, in order to unravel it, now that the jury has returned a verdict, what's your burden?
Burden is whether
to show us by a preponderance of the evidence that it would have.
That there was a miscarriage of justice.
And Lucady says a miscarriage of justice means what?
That I'm missing the first part. I'm a brain freeze. That the verdict is suspect, basically.
It has to be outcome determinative.
More likely than not.
Yes.
Outcome determinative, although it's interesting because in Snyder, then later, citing Lucady, we said it's outcome determinative if it undermined the reliability of the verdict, which is an odd way to equate things because I don't think those two things are necessarily equivalent. Let me ask you this question. There was a time in Michigan where we used to automatically reverse if a character instruction was not given. People versus Lane, I think, is the case from 1942. Now, under our current harmless error regime, can you think of any case in which we would conclude that failure to give this instruction would not be harmless? Any situation?
Would not be harmless?
Correct. If it's not in a case where the evidence is relatively weak and where the only evidence presented in opposition by the defendant is essentially character evidence, and the instruction is not given here, is there any case or any situation where it would not be harmless? Because you see, if there's not, I'm wondering why judges even bother wasting their time giving the instruction in the first place. Maybe we're creating incentives for judges to do what the judge did here and not pay too much attention to the instructions.
I would suggest there are certain cases where the failure to give this instruction would be considered harmless. If I understand the question correctly.
Yeah, I think that's his question.
Okay.
I don't think that's the answer he thought you were going to give, but I'm interested.
If not this case, when?
Well,
I mean, I should have asked the prosecutor, but I thought I'd give you a shot.
I was
at it.
thinking of a case where...
When would it be harmless?
Well, there's overwhelming evidence that a defendant had committed a homicide, where you have 5 eyewitnesses who said, yes, I saw him pull the trigger, and I heard him say, I'm going to kill you. Mm-hmm. Whether or not he had a reputation for peacefulness in the community.
Doesn't it also matter how strong his reputation for peacefulness is? The
part,
peacefulness
yes.
evidence? So like, if you have 7 nuns or, somebody, I don't know. Because here the evidence is, I used to know him and then I moved out of state. And I haven't seen him in 3 years except when I come back occasionally. And his old girlfriend who says, well, he never beat me. 10 years ago.
True, but if I recall correctly, that one witness also lived on the same street as Mr. Lyles did, as well as the victim did. And when she would go back, she would communicate with people in the neighborhood. And I would guess that being Hamtramck, being as it is, if there were rumors on the street, she would have heard about that and have told the defense about that.
Wasn't the character evidence here mainly of a collateral sort, designed to show that, designed to respond to the prosecutor who had said that episodes of domestic violence were committed against the mother in this case? The evidence wasn't mainly introduced, in my recollection, to show that defendant could not have committed the murder because of his good character. It was simply to respond to that limited argument that had been raised by the prosecutor. Doesn't that kind of diminish the breadth of the character evidence and what its purpose was designed to serve in this case?
No, I don't think so. In this case, the prosecutor presented all those alleged acts of domestic violence in order to sustain its burden of proving that he must have committed the killing. Supposedly, he was kicked out of the house, but there was no reason to blame Mr. Weathers, who I believe was the deceased in this matter, for why he was kicked out of the house. What the defense tried to do was to rebut all this allegations of uncharged domestic violence and convince the jury that he was a peaceful person. Therefore, since he did not do these acts that he was alleged to have done, he also did not do the killing.
It seemed to me that an argument can be made as fairly minimally probative of the ultimate issue of defendant's guilt, as opposed to whether or not he had engaged in the episodes of misconduct with the mother.
But then the question I would have is, why would the prosecutor bring in all these uncharged acts of domestic violence in order to sustain his burden of proving that he must have been a bad person, or not a bad person, but a violent person?
Right. Okay, well, thank you, Mr. Rust. Are there any further questions?
Can I ask the same question to the prosecutor?
Thank you.
Can you think of a case when failure to give the character instruction would be not be harmless error? Would it ever matter?
It would matter. I mean, what we have to do is we have to look at, the entire cause, as the harmless error statute instructs us to do. Now, I don't think that by finding that this is harmless error, because it is, there is not, the integrity of the validity of this verdict is not called into question because this instruction was not given.
I'm not talking about this case. I'm not talking about this case, although, I view this case as a case where the evidence is fairly weak. I don't doubt that it's sufficient to support the verdict. That challenge hasn't been made, at least it's not before us today. But I think it's fairly weak, only circumstantial evidence. There was no, even some of the evidence was lost. There was only testimony about the evidence. There wasn't even the evidence itself in this case. So the evidence is pretty weak. The only defense raised, as I understand it, by the defendant is this character evidence. So I'm just wondering, not about this case, but if you can generically describe for me the case in which character evidence will make the difference.
Limited to character evidence, I would be hard-pressed to find that situation if there are other instructions given, like in this case, where they're told they have to listen to all the witnesses. Now, there are cases where when an instruction is not given, it would be error and not harmless, like in this court's opinion in People v. Silver. The failure to give that instruction actually prevented the defendant from making that defense. And here, that wasn't the case. The defendant was still free to make that argument. He could have argued it in his closing argument, but he made no mention of that. So the idea that this piece of evidence would have changed the outcome, where they didn't even think it was important enough to make that argument in defense, which actually goes to Chief Justice Markman's point, is that this really wasn't a defense to say, I'm a peaceful person not capable of committing this crime, because if they actually thought that was their defense, they would have at least alluded to that in their closing argument. I know the Court of Appeals thinks that that is not important, and that still failure to give that instruction, in their words, eviscerated the defense, but they didn't even mention it in their closing, and it was one witness. Sorry. Yeah. Justice Bernstein?
No.
Oh, sorry.
He's not asking any questions.
But I know I don't have any time for my rebuttal. If there's any more questions.
Speak the rest of the day.
If there are no further questions, we'll thank you, Ms. Blanchard.
Thank you.
Okay. Case is submitted. Thank you.